Okay, this is a video about this. It's a notice of entry of judgment. Hard to see, but anyway, it is for Al Franken and Mark Ritchie, and it's from a 3-judge panel, which I had to force the Supreme Court to appoint. And as I'm going to explain here, they just totally botched it all up. They made a farce and a mockery of democracy and certainly of justice. Now, they're a little bit different court. This is a court of political law, and they don't have the right to attack our political rights and attack democracy, and yet that's what they're doing. Now, I'm going to read you a little bit from my motion to void this for the farce and the fraud that it is. And those are actual grounds for the motion to vacate this, set it aside, and to restart the trial and get the evidence that needs to go to the United States Senate. And so, I don't know, basically, I'm just going to show you without cut to the chase, and I'm going to go over this in this motion. Here's an order from this fine group of judges that basically says they're going to grant everything that Mark Ritchie wants without any delay whatsoever. And so I'm just going to skip over that, and I'm going to go to my submission. Please take notice that contestant, that's me, in a contest against Al Franken, moves the panel as set forth herein and is detailed and argued in the accompanying motion and memorandum. 1, for relief, voiding, and vacating both the December 30th, 2014 judgment, which was entered on December 31st, and today is the day with the 3 days for mailing that it needed to be filed and served, and I have done so. And the December 19th, 2014 partial order and issuance of the Al Franken Certificate of Election, and this is pursuant to Minnesota Rules of Civil Procedure 60.02D. The judgment is void. And C, fraud, whether heretofore denominated intrinsic or extrinsic, misrepresentation and other misconduct of the adverse party. And 2, for amendment of the findings, and the only amend specifically to strike basically all of it, and B, to find that Senator Franken's 2014 election certificate was issued in violation of Minnesota election law and of the United States Constitution based on a void proceeding, fraud on the court by Senator Franken and Secretary Ritchie, both Democrats, in violation of the United States Constitution, Article 1, Sections 4 and 5. And Section 5 gives the sole power, judicial power, to the United States Senate itself. And so everything that, and Al Franken is a judge in that, but Al Franken interfered with his own contest by going down to Minnesota and blocking this from proceeding. And Article 1, Section 4 says that the state needs to prescribe, that means write in advance, its election laws and then to follow them and to enforce them. None of that has been done. So that's the second part, amendment of findings and amending the judgments. And also on the grounds that the evidence for the issuance of Al Franken's certificate terminating the major political party status of the Independence Party, that's a big issue here, is insufficient. And for a new trial, and then for a stay of judgment, I'm just going to, don't want to get too much into the legalities of it without being clear. So here's the grounds for the motion finding this whole proceeding void. The judgment is void and a nullity on many grounds. The panel, that's 3 judges appointed by Lori Swanson, she's been elected as the Supreme Court Chief Justice, and she appointed the trial judge of the year, John Van den North, known for going after the Catholic Church and the Catholic parishioners for this extended statute of limitations that lets them go after all the Catholics because of things that happened 20, 30 years ago. None of it's been proved. And then they also had a Minneapolis judge and an Anoka judge, so a 3-judge panel. So being limited in its subject matter jurisdiction by the United States Constitution, Article 1, Section 5, and required by Article 1, Section 4 of the same to enforce the existing prescribed election laws, including Minnesota Statute 209-12, Congressional Office, yet disregarded objections and rendered an unlawful, unconstitutional judgment over the dispute between contestant and contestee and the state of Minnesota in the matter herein, that's of the U.S. Senate election, which has been used to destroy the Independence Party as a major political party in Minnesota, and to put and to give Al Franken a fraudulent, invalid certificate of election, which of course he hustled up to the U.S. Senate and presented to them. And this matter is a single contest with a set of implicit questions voted on statewide, including the validity of the U.S. Senate general election as it affected contestants' percent of the vote, and then by automatic operation of the law, the major political party status of the Independence Party of Minnesota, whose 2014 U.S. Senate nominee contestant is. So that's what this is about. Now B, in entering, these are two grounds there. These are different grounds for voiding this. In entering the December 30th, 2014 judgment, the panel acted in a manner inconsistent with due process of law, giving to Al Franken the election certificate by illegally ending the pending election contest on an irrelevant, frivolous motion by Mark Ritchie that he shouldn't be a party, a matter that is largely irrelevant and procedural and cannot end this contest, and also by improperly taking away the major political party status of the Independence Party of Minnesota based on this invalid Franken-Carlson election, November 4th, 2014, which is the subject of this election contest. C, another ground. The panel otherwise acted unconstitutionally in entering judgment where it is strictly forbidden, even by just Minnesota law, Minnesota Statutes 209-12, let alone the United States Constitution, Article 1, Sections 4 and 5. And the panel was directly informed of this limitation by contestant in writing and orally, that the U.S. Senate is the sole judges. And the panel, whether they call it a ballot question or not, are not the judges of this contest according to the leading case, Stephen L. Morgan versus United States of America from 1986, D.C. Circuit. And on this ballot question issue, the panel actually found the grounds presented were not regarding any ballot question, and contestant never called it that, but just a question voted on statewide. And this is the question of there's a number of questions, but one which I presented was the IP percentage of the vote. That's the ballot question, which resulted in taking away the status as a major political party. And I'll get more into that in just describing the grounds for these motions. So the panel was told the contest could not be bifurcated into just Al Franken getting his election certificate and running up to Washington as fast as he can on the one hand, and all other issues, including the loss of major party status by the Independence Party because of an invalid election on the other, all on the foreground stated in the election contest. Entering each judgment in violation of said constitutional provisions and Minnesota Statutes 209-12 is a constitutional violation voiding the judgment and the partial order. Now, res judicata, that has already been litigated, res judicata consequences of the illegal authorization by this panel to issue Franken his election certificate will not be applied to the panel's void judgment, which is one which from its inception is a complete nullity and without legal effect for the reasons herein. This is also true of the res judicata Secretary Ritchie keeps talking about in his briefs, which he believes arrives from the blocking of the 2012 contest against Betty McCollum, when the House of Representatives were again the sole judge of that election contest, because of that aborted contest was also void and a nullity. Here's a fifth ground. The judgment and the entire proceeding has merely the semblance, is a mere simulation of a valid judgment, without essential elements, including but not limited to: 1, discovery, which was not allowed at all. And I want to say on that Judge John Vandenorth opened the hearing saying, let's get this railroad started. Now, in stopping all collection of evidence and discovery, he opined that the U.S. Senate would conduct its own inquiry, but Governor Mark Dayton's invalid election certificate for Al Franken, presented to the Secretary of the Senate, was taken as sufficient grounds to seat Al Franken without the required operation of the law in the Minnesota contest provision. Mark Dayton's election certificate issuance was a fraud on the U.S. Senate. And that fraud was equally by Al Franken, who is a judge in the U.S. Senate, proceeding, and he's interfering in the Minnesota courts to prevent the due operation of law and the Constitution. And also by Chief Elections Officer Mark Ritchie, he also committed fraud in the issuance of the certificate to Al Franken. And I'm going to explain all this. So then the second element that's missing from this judgment, which is a mere simulation, is the final determination of all disputed questions, really the final determination of the contest by due process of law. That's missing. The opportunity for contestant to present his case, that's missing. The service of Al Franken's December 16th letter, which supplied his so-called motion to dismiss, that's missing. The lack of subject matter jurisdiction by the court, as explained supra and infra, is missing. Here's a sixth ground. The judgment is incapable of confirmation or ratification because the U.S. Senate never got the evidence suppressed by this panel, acting unconstitutionally and unlawfully. The seventh ground. The panel lacks inherent power to enter the particular judgment because the inherent power of judging elections and returns lies solely with the Senate, because that is a long-standing rule of all legislative bodies, so they will not be controlled by judges like this panel, and true democracy lost to the Republic. Here's an eighth ground for voiding this. The motion for judgment, each part, Franken's and Ritchie's motions to obtain judgment by dismissal, and I want to say on that, dismissal of the election contest by the contestee is not allowed by the Minnesota Statute 209-12 proceedings. And this was a fraud on the court by Al Franken and Mark Ritchie and Lori Swanson. And so returning to this issue, I'm looking for footnotes here without success. So this is not allowed, what they're doing. So the motion, each part, and severally, was from its inception, so the motion for dismissal, the complete nullity and without legal effect, because you can't win this kind of election contest by getting a judge to dismiss it. The motions to dismiss are not allowed by either 209-12 or sections 4 and 5 of Article 1 of the United States Constitution. It is an election of the people governed by the political laws which in this election contest should have, but have failed to restrain these fanatical partisans from going beyond what is allowed in democratic elections. Another ground for voiding it. The judgment is ineffectual to bind the parties which support a right, including the issuance of an election certificate to Al Franken, and of no legal force and effect whatever, and incapable of enforcement in any manner or to any degree, because it is a deformed semblance of the election contest filed and required by law. Another ground. The judgment is shown by evidence to be invalid for want of jurisdiction, and the evidence shows it is about the right of Al Franken to a congressional office and the right of the Independence Party of Minnesota's right to major political party status under Minnesota law. And to the judgment, it is a void judgment, and at all events has all attributes of a void judgment. The defect of jurisdiction which voids this contest relates to the subject matter, a congressional election contest, and the cause of action and the question to be determined and relief to be granted, in that the panel cannot be the judge or grant the relief it purports to, even of the matter committed to it by the legislature, which they say is the judgment that Franken received the most votes legally cast, because the legislature does not have that power to commit. And just to read from the leading case on this, in overturning the vote count, this was on a vote count by the Secretary of State of Indiana, based on a vote in the U.S. House of Representatives in which they rejected that vote count. In Stephen L. Morgan versus United States of America, again, D.C. Circuit 1986, Justice Scalia clarified what matters ordinary courts may entertain regarding elections. And he says, our holding today does not, of course, preclude all judicial challenges bearing any relationship to legislative resolution of disputed elections. It is conceivable, for example, that in investigating such a dispute, a House might go beyond its constitutional power to compel witnesses. In that event, a clear showing of such arbitrary and improvident use of the power as will constitute a denial of due process of law would justify limited judicial interference. That's citing Berry versus United States ex rel Cunningham. That's from the Supreme Court. Now, such a due process violation, however, must rest on violation of some individual interest beyond the failure to see an individual or recognize that person as the winner of an election. That substantive determination, which is the issue in the present case, resides entirely in the House. So again, this does not reside with this panel appointed by the Minnesota Supreme Court. It resides in the United States Senate. Now, and to the extent that the report on the canvassing board's count is not to be disturbed, the rest of the contest must still be completed. And so a so-called judgment purporting to determine the rights of the parties in this action or proceeding, that is to say, the election contest, the panel did not finally determine the contest as required by law. Instead, you blocked it, as the Minnesota courts have done since 2012. The panel lacks the power to do this. Another ground for voiding this: the panel is without jurisdiction to enter such judgment, which can only be entered by the United States Senate, who even on the matter of the candidate receiving the highest total of votes legally cast is the sole judge and not this panel. Another ground: the judgments and issuance of the certificate to Franken should be voided and vacated because Franken's and Ritchie's conduct constituted extrinsic and intrinsic fraud on the panel and on the U.S. Senate, deliberately preventing a fair adversary hearing in the Senate and fraudulently prevented contestant from presenting his grounds for invalidating the U.S. Senate 2014 general election to the U.S. Senate. The grounds being presented. Another one: Al Franken and Mark Ritchie committed fraud on the court and intrinsic fraud by scheming to prevent contestee from presenting my full case at trial. The panel's comment that the U.S. Senate would take this up and give me an opportunity is simply not realistic. Franken came up with this so-called motion to dismiss because supposedly the contest could not be justiciable in a Minnesota court. And then he modified his motion to eliminate the questions regarding Franken's right to office in a letter that was hidden from contestant, never served until after the so-called trial, December 18th, and actually never provided to me in that hearing, as Judge Vandenorth merely described it in the trial. Mark Ritchie backed Franken's illegal motion to dismiss and then introduced a frivolous motion saying he could not be a party. Of course, he's required to be furnished with the contest under the contest law. And Minnesota Statutes 209.021 subdivision 3, notice served on parties, requires that in all contests relating to the nomination or election of a candidate, the notice of contest must be served on the candidate who is the contestee. A copy of the notice must be sent to the contestee's last known address by certified mail, and a copy must be furnished to the official authorized to issue the certificate of election. Ritchie is that official. and does not need to be a party to participate. If he is removed as a party, then Franken is the contestee on these issues about the Independence Party and all the issues, and Ritchie still participates as that official because he also handles the downgrading of the IP's major political party status. And so to continue on this ground, they never let on that Ritchie believed the entire contest needed to be dismissed or ignored by the panel. So this is a conspiracy against democracy and the federal Constitution. Now to the grounds for a new trial and amendment of findings. That's appropriate based on these grounds. The findings of fact and conclusion of law to be stricken must be stricken because they are not allowed by either Minnesota Statutes 209-12 or the United States Constitution, Article 1, Sections 4 or 5. Specifically, whether or not there is a ruse by the panel and by Secretary Ritchie that some is explicating out a ballot question, pretending jurisdiction over that to the extent the panel rules there cannot, they say there cannot be such a ballot question, and therefore the contest against Franken can be thrown out. I mean, the whole thing is ridiculous. The election contest does not relate largely to the office of the United States Senator. That is rubbish. It relates completely to the U.S. Senate race. However, a number of inferences are being drawn from that single general election, and not just one. So, in fact, there was no ballot question voted on statewide like this. Quote, did Al Franken receive the highest number of votes legally cast, and therefore is he entitled to receive the election certificate? Now, did you see that question on the ballot? It was not on the ballot in Minnesota. No question in response answer. All that was there was candidates listed and the inference that could be drawn from the vote on of checking your selection of who you wanted to be U.S. Senator. Now, I simply said in my contest that were the U.S. Senate to find that the Franken election was not valid, and he is not entitled to take his office because it is not valid, or that in this case he is entitled to take his office despite not having won a valid election. And about that valid election, the four grounds of serious material and deliberate violation of Minnesota election law, which have not been discussed at all by the panel judgment. The panel pretends the validity of the election, but only the feasibility of having Minnesota courts that have enforced election laws allowing contestant as the Independence Party nominee in one or more publicly broadcast debates with Franken, allowing me to use public information in the form of voter email addresses for outreach to them during the general election, or being allowed to seek endorsement by DFL caucuses and conventions to build support in the general election, and then win the primary and attract DFL voters to my campaign against Franken. All of these things are material to the 5% threshold. So this is again reading from the grounds. So then it is an invalid election that took at least 2.6% from the Senate nominee, which would have kept the major political party status. In short, it is a question voted on statewide. The statute does not require that it be a ballot question, and Poser testified he was not an expert and could not interpret the statutes to say this was not such a question. And I show infra that this question is no different than the other inferences drawn from the U.S. Senate race vote count and percentage. So then, pursuant to the following grounds in Minnesota Rules of Civil Procedure, the motion is that the judgment be open and that the panel take additional testimony, amend findings of fact and conclusions of law, or make new findings and conclusions and direct entry of a new judgment, all as specified herein. So here's the first ground for a new trial and for amending, striking these findings. So Minnesota Rules of Civil Procedure 59.01a provides for a new trial where irregularity in the proceedings of the court or prevailing party or any order or abuse of discretion whereby the moving party was deprived of a fair trial. This proceeding was highly irregular. Motions to dismiss are not in order, and the election contest under sentence 3 and sequitur of 209-12 cannot be dismissed. And yet to pursue in open court these dilatory, impermissible motions, Mark Ritchie took up 1/3 of the less than 4 hours allowed by the panel. Franken's attorney took up another third, leaving contestant with just over an hour. And my testimony, which is the only material evidence on the record and undisputed, took up nearly 45 minutes, leaving less than 15 minutes to cross-examine Poser and make my legal arguments. The whole purpose of the trial is limited to collecting evidence. It is a ministerial duty presided over by judges because of their imputed honor and truthfulness and faithfulness and faith to the law, or faithfulness. And yet the panel cut off all my discovery because they said the urgency of the time prevented it. I was thereby deprived of a fair trial. Again, they refused to forward the record to the Senate. Further, the issuance of the election certificate by Mark Ritchie and Governor Mark Dayton to the Secretary of the U.S. Senate, which took place on December 19th, 2014, the day after the so-called trial, and when I did not even know of the December 19th partial order, which was not mailed to me until December 22nd, has violated Minnesota law, since Minnesota Statutes 204C.40 subdivision 2's time of issuance bars the issuance of the certificate, quote, until a court of proper jurisdiction has finally determined the contest, unquote, in the case of the contest. Now, as Secretary Ritchie concedes, the election contest had been filed, and the certificate could not issue, despite this panel's ideas, quote, until a court of proper jurisdiction has finally determined the contest, unquote, and that contest has not been finally determined. Now, the language used by the panel referring to determining the rights of parties in an action are wholly inapplicable here and indicates the voidness of this proceeding. The contest must be determined, not just some separate rights of the parties under Minnesota law. So, to proceed then, yet Ritchie attempts to avoid the law by citing in the Minnesota Supreme Court a case called Franken, Al Franken versus Palenti from Minnesota 2009, Minnesota Supreme Court, which they said the U.S. Senate race, contestant challenged canvass vote totals, and they quote, in Palenti, this court held that the term contest is used in section 204C.40 in the narrow sense of a chapter 209 proceeding, and invokes the Supreme Court saying the term contest in Minnesota Statutes 204C.40 subdivision 2 refers to contests initiated pursuant to the general election laws of the state, that is chapter 209, and not to the potential continuation of that contest into the United States Senate. This case is, however, is obviously overruled by Morgan Supra and is not good law. In any case, Morgan makes clear that only the Senate are the judges, not the judges in Palenti's case, even though they were the Minnesota Supreme Court. There may be some clear abuse of power issues, as are mightily present here, that the U.S. Supreme Court could address, and this panel should cease forthwith in its abuse of power. This is an election, not your business as usual court case. Okay, to proceed then, accordingly, a court of proper jurisdiction can finally determine a Chapter 209 election case involving an election for the United States Senate, and the contest tolling provision of Section 204C.40 subdivision 2 therefore applies to such an election, unquote. So what they're saying here, I know this is a lot of legalistic mumbo-jumbo, but what they're saying is they believe the panel was able to just cut this contest in half and decide that even though they didn't have jurisdiction, because the U.S. Senate had the jurisdiction. So basically they were not a court of competent jurisdiction, and only the U.S. Senate is competent. And again, that was a recount contest between Norm Coleman and Al Franken. This is not a recount, and this panel has admitted that it is not a court of competent jurisdiction on the sentence 3-209-12 contest, the any other points contest. which is about Franken's right to office because of his conduct in validating the election and other conduct in validating the election. And so the tolling provision of Section 204C.40 subdivision 2 as applied would require that the election certificate would not have issued under Minnesota law. My position and my request was and is that it should issue with the remaining other points of the contest and with the evidence that's supposed to be collected. Thus, this was an irregularity by the court and the prevailing party, Franken and Ritchie, justifying a new trial. Then B, misconduct of the prevailing party. Franken, who is backed by his DFL Chief Elections Officer Mark Ritchie, whose partisanship in his position has been well established on the record, first filed a motion to dismiss. If the panel will look at 209.12, there can be absolutely no role for a motion to dismiss. It is a conclusion of law and requires findings of fact, which are not allowed. Even Ritchie at the Minnesota Supreme Court agrees. Quote, thus, the issuance of a certificate of election to Senator Franken implies only that the Minnesota state government has determined, under the procedures set forth in state law, that Senator Franken has received the highest number of votes legally cast at the election. See Minnesota Statutes 209.12 sentence 1, says Mark Ritchie. Senator Franken's right to hold the office of the U.S. Senator remains, as both Article 1, Section 5, Clause 1 of the United States Constitution and Sentence 3 of Minnesota Statutes 209.12 provide, a matter for the Senate to decide, unquote. And this is correct, except that as Ritchie himself tells the Supreme Court, the issuance is not allowed when there is a pending contest. And if this is still pending, these other issues, they're still pending, then the contest is still pending. And it has to go to the Senate, and they cannot sit on it and dump it in the garbage as the panel did. It has to be taken out of the garbage, and this has to proceed. So the panel violated that rule that it can't issue when there's a pending contest, because that is what Franken misled the panel to do. Franken improperly filed, and he used up trial time for his dilatory and baseless motion to dismiss. And in fact, the contest was not dismissed and could not have been dismissed because, first, it did relate to the U.S. Senate contest, and two, it did raise points including serious material and deliberate violation of Minnesota election law, calling into question Franken's right to office, which needed to be certified and forwarded to the Senate. Now, the panel, for whatever reason, leaves out that portion of 209.12 that requires this evidence collected to be forwarded to the Senate. So you, the panel, have, with intentionality, mooted some aspects of the U.S. Senate, destroying this case because you followed improper procedure and refused to follow the law as I demanded specifically that you do. You have blocked the contest. However, the law can still operate to bring before the Senate Franken's behavior, and this motion seeks that. Therefore, it could not be dismissed by Franken or Ritchie, and the procedure was just vexatious and harassing. Now, secondly, Franken sent a letter, that's what they say, to the panel. This is fact 6 of page 2 of their findings, saying he amended his motion, and yet I was not served with this foolishness. Neither motion is allowed. The contest provision is clear, and it was discussed very clearly in the argument on Franken's so-called motion that you were refusing to follow the law, but instead following Franken's misconduct, whether he confused you or whether he simply provided a pretext for your panel to block the contest in a kind of dance with Franken. As a result, Franken used his motion and your actions to actually suppress this contest in the Minnesota court, running out the clock until he could get seated. This is further grounds why he has attained the seat by an invalid election, topped by an invalid contest, which is void, and which blocked my claims from being tried by the Senate. And it's not claims, it's grounds. And the misconduct of Mark Ritchie and Al Franken of filing that certificate with the United States Senate, which was an invalid certificate, is also grounds for a new trial. That new trial should be a continuation of the aborted or voided proceedings, and the U.S. Senate should be informed of the circumstances and allow the evidence to be submitted. That would normalize the contest under Minnesota law. Further, as Secretary Ritchie admits, this evidence should be part of the Article 1, Section 5 decision by the U.S. Senate. Since it is prescribed by the Minnesota legislature, it also violates Article 1, Section 4 of the U.S. Constitution not to do this. So here's another ground for a new trial: accident or surprise, which could not have been prevented by ordinary prudence. I could not have known that your panel would not allow any discovery, including the interrogatories I already served on Franken in Ritchie's office regarding these grounds for contest. And I served them before you set up the court date in the week-long hiatus when the Minnesota Supreme Court decided whether to appoint a panel, running out the clock. Now that clock has indeed run out, but the time element is no longer restrictive, and I want the contest reopened and properly finished, so the grounds for the contest can be evaluated, so the validity of the Franken election, which did result through invalidity in taking away a free and fair election, can be remedied. I did not know the panel on Ritchie's silly motion that he should not be a party would bury the entire contest without allowing any evidence except that at trial. I argue that the Independence Party of Minnesota may not be deprived of major political party status in an invalid election and a rigged election contest proceeding. I could not have known that Franken would file a motion to dismiss rather than allow the legal proceedings, that he would file a letter altering his motion without my knowledge, or that Ritchie would make or imply an argument that the contest should be dismissed where it is not allowed by law, where dismissal is not allowed by law, just because I served him as a party and because I noted that the question of IP status was voted on statewide. It is a surprise that the panel would do this, since the disputed issues in the any other points part of the contest have never been determined. Here, the required determination by the panel is not to judge, but it is to act in a limited role established by the legislature, prescribed by the state legislature in the election or selection of senators for U.S. Senate. And you should do this role. You are required to. It is part of the determination, just as it is part of the determination to record the vote totals. All of that must be judged only by the Senate. No final determination on the election contest can be made outside the Senate. So to proceed on with this, I'm jumping in and out of footnotes. Here's another ground for a new trial: errors of law occurring at the trial objected to at the time and plainly assigned here in the notice of motion. I pointed out to you directly in the argument against Franken's so-called motion and amended motion not served on me that you must take all this evidence and your findings on the count and forward it to the Senate. Judge Doug Meslow stopped me and said, quote, "I just want to be clear. You're saying we have no choice but to collect this evidence and forward the record to the U.S. Senate," unquote. I told him yes, and cited Morgan versus United States, discussed at length in my December 22, 2014 submission to the panel. Judge Meslow refused to say whether he disagreed, but in fact the actions of your panel make clear you declined to follow the law and allow the evidence. And I did object to this on the record, saying it would void the proceedings and would block the contest. And now you have, and I want you to reopen these proceedings. Here's another ground for a new trial. The decision is not justified by the evidence or is contrary to law. Because the panel refused to allow the evidence to be collected, and because the panel insisted on acting as judges and entered an order to quote-unquote dismiss the contest, the decision is not justified by the evidence and is contrary to law. It violates Minnesota Statutes 209-12, which requires that the panel have allowed discovery and collection of evidence, certification, and forwarding the entire record to the Secretary of the United States Senate, together with your findings of fact and conclusions of law only on the matter of who got the highest number of legally cast votes. This statute clearly makes no provisions for motions to dismiss or dismissal, and certainly does not allow a member of the U.S. Senate sitting in its judiciary capacity to attempt to block the proceedings, which Al Franken did. Also, it violates 204C.40 subdivision 2, which precludes issuing an election certificate until a court of competent jurisdiction has finally determined a contest. The fact that findings of fact and conclusions of law by this panel are allowed by state law on some issues, however, does not empower this panel to find it is a, quote, court of proper jurisdiction who has finally determined the contest, unquote. The panel cannot and did not finally determine the contest, and so it violated by forwarding that election or issuing that election certificate from Mark Ritchie and Mark Dayton to Al Franken. Should not have issued. Violates Article 1, Section 5 of the Constitution, which clearly, textually commits the role of judge to the U.S. Senate and excludes all others, particularly those who are called judges. See again, Morgan. It violates Section 4 of the same, which requires Minnesota, including this panel and the Minnesota Supreme Court, to adhere to the election laws prescribed by the legislature, including this panel and all Minnesota courts, to respect and enforce those procedures and not abandon them or improvise or do what, in Judge Vandenorth's opinion, quote, is the kind of trial I think the law intended, unquote. Vandenorth said this specifically at the close of the December 18th proceedings. And it also violates the 14th Amendment and the 5th Amendment, requiring due process at the Senate and in the Minnesota state government regarding this election. Here's the reasons for a stay of judgment temporarily and permanently. First, the expedited proceeding the panel ordered, which is like 1 day, is not now required to be expedited because of the actions of the Senate January 6, 2015. But that the contest persists and its conduct and constitutionality remain subject to judicial review by the state and federal courts. So that's the reason to stay it. That the proceeding as ordered by the panel was null, void, and invalid as a result of the highly irregular conduct, and the actions of the panel on December 30th did not remedy this, but further violated the law, denying availability of judicial relief as part of the time, place, and manner prescribed by the legislature for conducting elections and contests in congressional races. For instance, as part of the purported dismissal and final determination of the rights of the parties, the panel is not even making the record of the proceedings available to contestants, far less the U.S. Senate. You are reaching into the Senate case and mucking it up, attempting to ruin the case related to Franken's right to office. You are establishing by illegal means his right to office in the face of a contest which was not disposed of. And it does not comport, this proceeding does not comport with the clear requirements of Minnesota election law and the U.S. Constitution. Therefore, the judgment may not be put into effect. And further, all the 5 factors considered by the court, according to the Dahlberg brothers, weigh in favor of the state. Now, Dahlberg brothers is used by all Minnesota courts to determine whether or not they should issue a stay in any given case. So first of all, the first factor, the relationship between the parties pre-existing the dispute giving rise to the request for relief, this needs to be preserved in the interest of all the parties, including the U.S. Senate and the American people and the rule of law, and our hope for democratic government. In other words, we don't want to mess with this until we know that we're following the law. And the second one, following the U.S. Constitution and election laws, is the definition of the good for America, including contestees, and actually aids them in their legitimate purpose, including the function of the U.S. Senate for Franken. He wants it to be due process and valid. By contrast, destroying the relations pre-existing the dispute, giving rise to the request for relief, is a threat to the rule of law. If all the rights are taken away that exist as part of this contest, it's a threat to the rule of law and democratic elections in our very Constitution. It will wrongfully take away rights from the independent voters and the independent party. 3, the likelihood that one party or the other will prevail on the merits when the fact situation is viewed in the light of established precedents, the limits of equitable relief, particularly that the proceeding from which the judgment proceeds is null and void under law, and a new trial and amended findings, including striking findings, is required by law. So this, the likelihood weighs in my favor. And then the aspects of the fact situation which require consideration of public policy expressed in the statutes, state and federal, are stated herein. Yes, that weighs in my favor. The administrative burdens involved in judicial supervision and enforcement of the temporary decree. This panel should stay the operation of the law based on this invalid election, leading to the termination of the major party status of the Independence Party of Minnesota, because this will create administrative burdens in the 2016 elections, which are unnecessary until this matter is resolved. So this is the end of just the motion and the grounds for it. There's three parts that we need to void the action of the court so far, including the issuance of Al Franken's election certificate, because it's contrary to Minnesota law, and because of the fact that the trial was not allowed to proceed. It's based on a kind of proceeding which was never allowed by law, so it was therefore void and null from the very beginning. And the other ground stated there needs to therefore be a new trial. This trial needs to continue. Now, in this case, all a trial is collecting evidence about these four grounds. These four grounds being the fact that the courts would not enforce the law, that Al Franken excluded the Independence Party nominee from all the elections which he scheduled, and this violates the law. I need this to be looked at by the Senate and the courts. The fact that Mark Ritchie refused to allow public information in the form of voter email addresses to be used by me in my campaign to level the playing field. And finally, the fact that you have these gender quotas, these race quotas, homosexual quotas, which are in the DFL Constitution and enforced by state law. You cannot participate in DFL precincts, caucuses, and conventions, or in conventions, unless you agree with these. And in every case, there have to be a majority of women, but not only that, the white male vote is restricted down to about 35 to 40%. This abridges and denies the right to vote, which cannot be done according to the 19th Amendment to the Constitution because it's based on our sex, and cannot be done according to the 15th Amendment because it's based on our race. So what I'm saying then is we need to go on with that trial. We need to strike these ridiculous findings which have not disposed of the contest, and then we need to stay the judgment until we can get things on track. So this has been filed and served on Al Franken's attorney, Charles Nowen, and also on Mark Ritchie's attorney, Nathan Hartthorne of Lori Swanson's office. And they should be responding to this, and I'm going to ask that this contest be restored and carried through for its lawful function. Now, in the next video, I will read you the memorandum of law, which I think you'll find is quite powerful. This is not just trivial technical stuff. This one guts American democracy and is a real threat to not only the First Amendment, but the entire federal government and to our Constitution.